This conference is now being recorded.
Good afternoon. Welcome to the New York ASBO webinar of Fair Labor Standards Act. My name is Matthew Darius. I'm the Senior Staff Associate for Professional Development and Services here at New York ASBO. Our presenter today is Michael Dodd, lawyer from the Ferrara and Fiorenza firm in East Syracuse, New York. And if you have any questions for Mike during the presentation, please feel free to hit #pound on your phone. That'll notify me that you have a question, and I will break in, and you'll be able to talk directly with Mike. Otherwise, you can go ahead and feel free to use the chat window. And without any other points of interest here, Mike, please go ahead.
All right, Matt, thank you. Just a little bit of background. My particular area of the law is in private sector labor law primarily. I deal with the Fair Labor Standards Act with private companies all the time. I happen to work for the Ferrara Fiorenza law firm that represents 100 plus school districts and BOCES throughout the state. So I'm glad to have this opportunity to talk to the side of the practice that I don't often get a chance to talk to. Let's talk about what we're going to kind of give us a roadmap of where we're going to go today. First of all, I want to give you some basic rules about the Fair Labor Standards Act and really just describe the legal arena that we're operating in when we're dealing with this particular law. Specifically, we're going to go into what are the exemptions from the Fair Labor Standards Act or from the overtime and minimum wage requirements of the Fair Labor Standards Act. We're going to discuss hours worked and why that's relevant. We're going to discuss timekeeping and record keeping, which over the last few weeks has been a topic that a number of our clients have been calling and talking to me about, and I can share some of the stories with you about that. Then I want to get into some of the pitfalls that we see on a regular basis with school districts in dealing with the Fair Labor Standards Act and wage and hour laws in general. And I want to talk about what the results are or what the ramifications are of making mistakes in this area and how likely is it that you can be audited, what are the potential penalties and fines that you could expect if you have those problems. And lastly, assuming we have enough time, I'm going to spend a brief amount of time right at the very end talking about youth employment. All right, first thing I want to talk about is the legal arena that we're operating in here. The Fair Labor Standards Act is a federal law. It is supplemented by the Equal Pay Act, but it's also supplemented by New York State law. New York State Department of Labor puts out its minimum wage orders. These have information in them about various things like what can be taken as allowances against minimum wage. What is the minimum wage for this particular time? Remember that minimum wage can be different. The state minimum wage can be different from the federal. Typically, New York is higher than the federal, but at the current time, they are at the same at $7.25 an hour. But there's also a new law in New York State, and I'm not going to spend a whole lot of time talking about it, but I do want to at least alert you to it, and that is a law called the Wage Theft Prevention Act. I mention it because there's been a lot of misinformation out there about the law. It's a state law, and the misinformation has been that it does not apply to school districts or to BOCES. And I'll explain it a little bit later, but a certain portion of the law does apply, and you will be expected to comply with that law, and there are pretty onerous penalties if you don't. These federal laws are enforced by the U.S. Department of Labor, or the DOL as I might refer to them throughout the program. They perform the audits and assess fines and penalties, and they can also sue you to enforce the law. But the main way that a lot of these laws get policed or enforced is through employees suing you either individually or collectively to enforce or to get the wages that they feel that they are owed, et cetera. You may have heard recently that the Supreme Court made a ruling in the Walmart case that did not allow employees to form a class for purposes of a class action against Walmart. That was a discrimination case. It had to do with gender discrimination in particular. The female employees had brought this action against Walmart to try to make a case that Walmart has systemically, or has as a matter of its practice over the years, not allowed women positions of managerial positions, and have not paid them what they have paid their male counterparts. That is not that does not apply in this context. When we're talking about wage and hour laws, the courts are very willing to create classes for purposes of class actions in these matters, so they can become quite costly once they get into the litigation stage. So what are the basic rules of the Fair Labor Standards Act, or the FLSA? I was struggling with myself trying to come up with the simplest way of describing what this law does. And what you see on the screen is what I came up with. First of all, employees have to be paid for all the time they're worked. I know that sounds real simple, but we're going to see how that gets complicated here in a minute. Now, those who are properly classified as non-exempt, and what we mean by non-exempt means that they are not exempt from the overtime and minimum wage requirements of the Fair Labor Standards Act, are entitled to overtime pay, or a premium pay, after they've worked 40 hours in a week. And what the law says is that overtime has to be 1.5 times the regular hourly rate. Finally, the non-exempt employees are also entitled to minimum wage per hour, and as I said before, it's $7.25, which is both the state and federal minimum wage. Now, as simple as that may sound, even on this slide, I can kind of highlight those things that are going to present problems for us. In that first bullet, the employees must be compensated for all time worked. Well, what do we consider time worked? That's a very complicated issue. Second of all, properly classifying someone as non-exempt. Well, what do we mean by that? I'll be talking in a few minutes about white-collar exemptions and what they are, and what you need to know about them. And a lot of times it's a very gray area. It's very difficult to say for sure whether somebody is or is not exempt from these requirements. Notice the 1.5 hours, 1.5 times the regular hourly rate for overtime pay. I'm asked this question all the time. Well, aren't people entitled to double time on weekends or triple time on holidays? No, the law does not require that at all. Now, this brings up an issue that we're going to have to keep in mind throughout today's program. That is, what does your collective bargaining agreement say? You may have a collective bargaining agreement that says, on holidays a person gets paid double time, or they get paid triple time for weekends or something of that nature. That is often the case. But understand that all the law requires is that an employee get paid time and a half after 40 hours in a given work week. Your collective bargaining agreement can also shorten the work week. I know a lot of school districts have CBAs or collective bargaining agreements that say that we consider a full work week to be 37.5 hours, and any time worked over that is going to be compensated at the overtime rate. But what I'm trying to give you right now are the basic rules of the FLSA. It may need to be modified depending on how your contract is written, and that may need to be reviewed when you're making any determination about when an employee is paid overtime and what they may be owed. These basic rules become very complicated with respect to proper classification of exempt and non-exempt employees, and this is a kind of a minor roadmap of where we're going to go over the next 30 or 45 minutes. What work is compensable, what is considered time work for purposes of pay, timekeeping issues, record-keeping issues, compensation methods and calculations, and I'll explain what I mean by that when we get there. And lastly, a special issue that I know a lot of school districts and BOCES deal with, and that is volunteer service. Can we allow our employees to volunteer, and under what circumstances can they volunteer? And we'll get into that in a few minutes. All right, first of all, who is exempt? Well, exempt employees include professional employees such as teachers, administrators, some computer employees, and managerial employees. These are the so-called white-collar exemptions from the Fair Labor Standards Act. All other employees are considered non-exempt and are entitled to overtime pay. Now, one of the major misconceptions about this, and I hear it all the time, both in the dealing with both public and private sector clients, and that is, well, so-and-so is paid on a salary basis, so therefore they're exempt, right? No, that's not how it works. Just because somebody receives a salary does not necessarily mean that they'll be exempt. Now, we're going to find out here on the next slide that salary basis is critical to maintaining that exemption, but it is not the only criteria that must be met in order to prove someone is exempt from overtime. So let's talk about, I'm going to talk about basically four exemptions, four white-collar exemptions. The first one is executive, the second one is administrative, the third one is professional, and then the last one will be computers. I'm not going to deal with some of the other exemptions because they don't typically apply in school districts, like outside sales representatives, things of that nature. But these are the main ones that you as school people are going to be dealing with. The first one is the executive exemption. Now, you'll see that there are four bullets on the slide in front of you. And understand that all four of these elements have to be satisfied in order for someone to be considered exempt from the Fair Labor Standards Act under this exemption, okay? First thing is they must be compensated on a salary basis at a rate not less than $455 a week. You can do the calculation. I think it comes out to $26,000 or $28,000 a year. So that's the salary amount is usually not a difficult threshold to meet. But you'll notice that I've highlighted the phrase salary basis. Now this doesn't mean just that the person receives a salary. This is a very detailed and often litigated issue in wage and hour law. Salary basis means that the person is entitled to receive their salary, and this is what it says, regardless of the number of hours they work in a week. Now, that's not exactly true, but that's what it says, and that's kind of the default position that you have to start with. If a person does any work in that week, they're entitled to all their salary for that week. Now, are there exceptions to that? Absolutely. Give you an example. The first week that an executive begins work, if they only work 3 days that week, then they only need to be compensated for those 3 days. The same for the terminal week or the last week that they work. If they only work 2 days that week, they're only entitled to a prorated amount of salary for that week, amount of for 2 days. But the one area that a lot of employers get into trouble with is in the area of docking employees in those weeks in between their initial week and terminal week, where let's say that an employee says, I'm going to take a couple of days off. I need to take my son to college. I had to do that last year for the first time. So I'm going to take a couple of days off, and that's now the question is, can you dock that employee, or could you dock me for those 2 days that I took off? Well, the answer is yes, because there is the regulations under the Fair Labor Standards Act say that as long as an individual is taking a full day off, and it is for personal business, then the employer does not have to pay the individual for those full days. Now, What if my son was going to, a college close by and it's only going to take me a half a day? Could you dock me a half day for that time? Answer is no. If I come in and work any time that day, I should get paid for that entire day. It's only full days that you can dock. Another situation is if an employee has, if you have what the regulations called a bona fide sick leave plan. Give you an example. Let's say that you have, understand this, there's nothing in the law, both federal or state, that requires an employer to give employees sick leave per se, paid sick leave. Now, there is the Family and Medical Leave Act that gives employees job guaranteed leave, but that's not necessarily paid. That's unpaid leave that they can take off. But if you have a paid sick leave policy, let's say that you will pay an employee for 3 sick days in a year. If that is an employee that you are trying to say is exempt from the Fair Labor Standards Act, then if that employee is absent for more than 3 days, then for those days that that employee is sick thereafter, you can dock that employee for those full days, okay? So it's one of those things that you need to be very careful about saying that this person is getting paid all that they are entitled to. If they are not paid on a salary basis, then the exemption is lost, okay? Now that could be a very serious matter, because what the regulations say is that, let's say, for example, that we have an employee that we claim is exempt from the Fair Labor Standards Act under the executive exemption. And that employee takes time off every week, takes 3 hours on Friday every week to go play softball, and we dock that employee for those 3 hours every week. Well, now we are not treating that employee as a salaried employee. We are treating, under the law, that employee as if he or she were salaried, were hourly. Under those circumstances, that employee's exemption would be lost, and they would be entitled to overtime compensation if they worked more than 40 hours in that week. Now, the problem is that you can lose the exemption permanently. If we were to have this kind of pattern or practice of docking these exempt employees on a partial day basis over a period of time, then that employee is no longer going to be considered exempt. They're going to be entitled to overtime, but the regulations take it one step further. They say not only is this employee non-exempt and entitled to overtime, but every other employee in that employee's class is non-exempt. So you can see how the ramifications there can be very harsh. Now, the law does give employers a safe harbor, a way of avoiding that consequence or that penalty of having all others in that class treated as non-exempt. The first, in order to take advantage of that safe harbor, you have to have a policy specifically against doing the kind of thing that I just described. In other words, against the idea of treating an exempt employee as hourly. You have to reimburse the employee for any improper deduction that was made. And lastly, you have to make what the regulations say is a good faith commitment to comply with the law in the future. And I guess what that means really is you have to demonstrate over a period of time that you are not making these improper deductions from that employee or any others. All right, so that's just the first element of this executive exemption. And it's important that we spend some time with that, because that's kind of a common thread that goes throughout most of these exemptions, and that is that they are compensated on a salary basis. Now, the second element of this exemption is that the primary duty that this individual must be engaged in is the managing of the enterprise, department, or subdivision of the enterprise. Now, primary duty, I could probably spend a day describing what that means. The rule of thumb is if you spend more than 50% of your time doing it, if the majority of your time is spent doing it, that's probably going to be your primary duty. Now, if you want to get into some specifics about it, there are situations where, depending on the importance of the duty, maybe if you spend 45% of your time doing it, well, then that's going to be your primary duty. But basically, just the rule of thumb is 50% or more managing the enterprise, department, or subdivision. Now, that's just the first two elements. There's a third element, and that is that the employee that we're talking about must direct the work of at least 2 full-time employees or the equivalent. And what that means is that's basically 80 hours of supervision. In other words, you've got 2 40-hour employees that this individual directs their work and supervises. Now, it can be 2 individuals, or it could be 4 part-timers or 6 part-timers or 8 part-timers. It really doesn't matter, as long as you're hitting that 2 full-time employee threshold. There is some case law that suggests that an employer, let's say that your collective bargaining agreement says that a full-time employee is any employee that works 37.5 hours in a week. If the individual is directing the work of 2 or more individuals that work 37.5 hours a week, you're probably going to be okay with this exemption. But don't take this lightly. There is a whole series of cases where employers have been found to owe employees a lot of money for overtimes, especially for a misclassification of the employee as exempt under this law because of this very issue. If a manager is only managing 1 full-time employee, and you can't share employees. In other words, if you have a manager and then you have an assistant manager under that person and then you have 2 employees under those 2, well, the manager is going to be exempt because they are directing not only the 2 full-time employees but also the assistant manager. So that's 3 employees that the manager is actually supervising. But is the assistant manager supervising or spending the time supervising the 2 or more full-time employees? Maybe not. So you have to keep that in mind. Lastly, to be an executive or a bona fide executive or to qualify for this executive exemption, you have to have the authority to hire or fire, or really significant input into recommending the hiring, firing, advancement, promotion, etc. of the individuals that they are managing. So who does that really relate to in a school district setting? Well, assuming that all of these criteria are met, your administrators, your building principals, certainly the superintendent, transportation supervisors, building and ground supervisors, food service supervisors, possibly, cleaning crew supervisor, possibly. But remember, if they spend most of their time, more than 50% of their time, doing what their employees do, then they are not going to be considered exempt. And if we go back, it's because of this primary duty requirement, this second bullet in this on this slide, that their 50% or more of the time must be managing the enterprise, not doing the frontline work that their employees are supposed to be doing. Now, understand that you can qualify under a number of exemptions. It doesn't really matter, but I'm going to use the administrators as an example. Administrators are most likely going to qualify under executive exemption if they supervise two or more individuals. But even if they don't, they're probably going to be exempt under a different exemption, and that is the administrative exemption. How is that for a segue? We're going right into the administrative exemption. Again, you have to be compensated on a salary basis. I put the word or fee basis here, and I really wish I hadn't because it just complicates matters, but a fee basis is a situation where it's really not applicable to long-term employees. The example that the Department of Labor gives is, let's say that you pay an artist to paint a picture, you pay them $250, and it takes them 20 hours to do it. Well, if it took them 20 hours to do it, 40 hours in that week would be the equivalent of $500. Therefore, they would meet the $455 a week threshold. But don't get caught up in that. It's really if the person is paid on a salary basis, just like the executive exemption, and they receive not less than $455 per week. Now, in this exemption, the primary duty, again, 50% or more, must first of all be office or non-manual work, and it has to be directly related to the management or general business operations of the employer. This is where a lot of people get, this is probably the most confusing exemption, and because it is so, I think a lot of people incorrectly will just say, oh, if I'm not an executive, then I must be an administrative exemption. Not necessarily. This is actually kind of a very narrow exemption when you start to think about it. The idea is that the primary duty of this employee must be related to the management or general business operations of the enterprise. Maybe the best way I can describe it is picture a factory. Let's say we've got a widget factory. If you're working on the production line, if you are on that assembly line making the widget, whatever widget is, then you are not involved in the general business operations or the management of the factory. Now, if you are in human resources, or if you're in accounting, or if you're in quality control, then you are involved in servicing the business, not the customer, okay? In the context of a school district, if you are involved in providing services to students or to the general public, if that's your primary duty, then you're not going to qualify for this exemption, okay? The last part of this is your primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. This is another area that can really trip up people, but these are the main requirements of the administrative exemption. So who does that apply to in the context of the school district? I put district clerk down here because I think that the district clerk creates one of those gray areas. A district clerk is definitely dealing with matters of significance, and they, most likely are being paid on a salary basis. They're being paid more than the minimum threshold. They are definitely dealing with the management and operation of the business, but the question becomes, are they exercising independent judgment and discretion? I was looking at a booklet today on the responsibilities and obligations of district clerks, and it's very regimented. It's spelled out in the education law. This is what the district clerk is supposed to do. They're supposed to do this. They're supposed to do that. It's all spelled out for them. Now the regulations, the FLSA regulations, talk about if someone that we're trying to say is exempt under the administrative exemption, if they do their work based on a manual or what people tell them to do, that's not going to be the exercise or the independent exercise of judgment and discretion. So, it really depends on what the district clerk is doing in your district. Very well, I can imagine numerous situations where a district clerk would be exercising independent judgment, but you want to make sure that is highlighted in some way. One of the things I wanted to say a little earlier, but I'll take the time to say it now, is how do you prove this? Let's say that we're in front of the Department of Labor, or worse, we're sitting in a courtroom. And we've got an employee, former employee who's saying that I was improperly classified as exempt. And I actually worked overtime. I worked 80 hours a week for 6 years, and I want my overtime at time and a half, my regular rate for that 6-year period of time. you can figure out in your head how much that's going, how expensive that might be. How do you prove that the person was properly classified? Well, there's a number of things that the courts or the Department of Labor are going to look at. The main evidence that they're going to look at is, what does the job description say? Now, that's not going to be absolutely controlling, but I would encourage you, if you have an employee that is kind of on the, you're not really sure if they're in that gray area, or you're not really sure whether they are or are not exempt, then pay close attention to what their job description says. Remember what these duty requirements are in order to qualify for that exemption. Write the job description to include those requirements, those duties. And I would do that for the executive exemption as well. I mean, I would state somewhere in the job description, employee, whatever the job title is expected to routinely supervise the work of 2 or more full-time employees. Just put it in there. Now, the reason why it's obviously not going to be controlling in all situations is if your job description does not actually describe the facts of the situation. Understand that the Department of Labor is not just going to take your word for it. They're going to come in, they're going to talk to the employee, they're going to ask them what their duties are, and really determine whether or not it fits. But I think it is a worthwhile exercise to go through your job descriptions, especially in those marginal cases, and determine whether or not they are properly classified, and try to bolster that by including the duties that are specifically stated in the regulations as being necessary elements of the exemption itself. In the school district context, certainly if you're involved in human resources, or you're a personnel director, or business officials, obviously, you are all going to be exempt under this exemption. Why? Because you are exercising independent judgment and discretion. You are dealing with the business operations of the district. You are not necessarily servicing the public or the students. But remember, a majority of the time must be spent servicing the district operations, not the public. That's how you get to that exemption. The professional exemption, I'm not going to spend a whole lot of time on. This is basically your teachers. Teachers and administrators are going to qualify under this if the primary duty is to perform work requiring advanced knowledge. If you are required to get a college degree to do it, and you are teaching or providing instruction, then you are going to be exempt under the professional exemption. So your administrators and principals, even though they may be executive exemption, may be qualified for the executive exemptions, they are also going to be qualified for the professional exemption. Certainly full-time teachers are going to qualify for this exemption. Probably not teaching assistants unless they spend a majority or more than 50% of their time teaching. And I know for a fact, having dealt with this particular issue with the Department of Labor not too long ago, aides are not exempt. There's we used to believe that really the cutoff point was for certificated employees. But teaching assistants get certificates, and they are typically not going to be exempt under this professional exemption. So there is there's not it's not a clear line distinction based on if you get a certificate as opposed to if you don't. But if you do have a teaching assistant that is spending a majority of his or her time teaching, then you may very well have a professionally exempt employee. Again, you want to document that. You want to be able to prove that. How do you document it? Well, it's probably not going to show up frequently in your job description, but making some sending the individual a letter or a memo clearly stating that you are spending 70% of your time teaching. This is to notify you, or this is to reflect our records that this is what you're doing, and that would certainly help to bolster your position if it ever came down to a dispute over whether or not the person was properly classified. Computer employee exemption, this would relate to any IT staff that you might have. and when I say relate to, it doesn't mean that just because they're IT staff, they are automatically exempt. They are not. In fact, it's an interesting thing the way that the regulations talk about it. They say that the individual has to be employed as a computer systems analyst, computer programmer, software engineer, or other similarly skilled worker in the computer field. But then the very next line it says, but their job title is unimportant. So why did they bother even saying it? So I guess my point there is, don't simply think that because you are giving an IT person a title of computer systems analyst, that they're automatically going to be exempt. The primary duty for those employees is really the application of systems analysis techniques and procedures. I'm sure there are some of you out there that know what that means. I'm basically a computer illiterate, so I'm sure that there are ways of knowing whether or not a person is applying systems analysis techniques. It also includes if they're spending, again, 50% or more of their time designing, developing, documenting, analyzing, creating, testing, or modifying computer systems or programs, including prototypes, etc. Those individuals can be compensated on a salary basis of, again, $455 a week, but they are one of the few, well, actually the only exemption that I'm aware of, that can be paid on an hourly basis. They can be paid, as you see the number there, it's $27.63 per hour. But again, it's only for very specific computer employees that can qualify for that exemption. All right. So the first issue is the person exempt from the overtime requirements and the minimum wage requirements of the Fair Labor Standards Act? The answer is yes, if they met all the criteria for the executive exemption, the administrative exemption, the professional exemption, or the computer employee exemption, then they do not have to be paid overtime. For all other employees, we call all other employees non-exempt employees, okay? So what time or what work time do they have to be paid for? That's the next issue that the Fair Labor Standards Act deals with. Basic rule, again, starting simple and becoming increasingly complex as we go through this. Basic rule is all time spent working is compensable. They have to be paid for all time working. Sounds simple, but it includes a lot of situations where employers might not normally think that the employee is working. And as we discussed with the exemptions and how do you prove that, bear in mind as we go through this discussion, how do you prove or disprove the time worked, especially under, let's say, the first circumstance, which is work done at home? How are you going to know? Well, the employee is going to have to tell you about it, obviously. But let's say that we have a secretary that calls subs in the morning, and rather than coming into the office to do that, he or she is making those calls from home. Is that compensable work time? Absolutely. Absolutely. Is the employee going to have to tell you that they're doing it? Well, yeah, they are, but if you know that that's what they're doing, for example, let's say that you're in at the time that these calls are made, and you see that that individual is coming into work, an hour later. Well, then you are aware, you knew or should have known that employee was working from home, and you would be really on the hook for investigating and asking the employee, well, how many hours did you work, or how much time did you spend working at home? Now, remember, this doesn't apply to teachers, right? Teachers are exempt. But for non-exempt employees, my wife happens to be a teacher assistant, and I know how much work that she does at home. Now, she is non-exempt, and she should be compensated for all those hours that she works at home. If she tells the school district about it, then she is definitely going to get paid for it. Work done before or after regular hours or on weekends has to be paid as well, even if the employee is directed not to. Okay? Years back, employers used to put in their handbooks, their employee handbooks, do not work any overtime unless you are specifically authorized to do so by your supervisor. If you work any overtime without proper authorization, you will not get paid for it. Wrong. Can't do that. Absolutely a violation of the law. It's a principle of the law. It's called you as the employer have suffered or permitted the employee to work, therefore you owe that employee for that time worked. Now, if you have an employee that is working overtime when you directed them not to, you can discipline that employee for that, but you have to pay them for it. So the appropriate way of addressing the situation where an employee is working time that they're not supposed to is through discipline, not through not paying them. Attending a school board meeting after hours, either to take minutes or to perform other required or assigned duties, is definitely compensable time. If that person is non-exempt, let's say we're dealing with a secretary or a district clerk who is maybe not qualifying for that administrative exemption. Well, the time spent at the board meeting taking minutes and performing any other required duties, that's going to be time that's going to have to be paid on an hourly basis. On-call time. If an employee is required to remain on the employer's premises or so close that it really makes the time unusable for the employee for their own purposes, then that is compensable time. Well, but wait a minute, they're not actually working. Well, I know, but that's what the regulations say. Really what the rule of thumb is if the employee is completely free to use the time as they want, and they could leave the premises or go and do shopping or go to a movie, then okay, that's not compensable. But if they're required to stay on your premises and or they have to, they can't go and do the things that they would normally do in a day because they might be called in, that's going to be considered on-call time and have to be compensated. One of those situations, or a similar situation, is meal periods. Under New York state law, understand that all employees are entitled to at least a 30-minute lunch period. And how that's described is as a duty-free lunch period. Unless an employee is completely relieved of all duties and free really to leave their duty station for at least 30 minutes, then they have to be compensated for that time. Now understand the catch-22 you're in there. Ultimately, if you determine that, let's say you have an aide who eats their lunch in the cafeteria but is doing so because one of their duties is to supervise students, well, then that aide should actually be compensated for that time they spent in the cafeteria. Problem is, New York state law says that the aide should have been given at least a 30-minute duty-free lunch. So while you are complying with the Fair Labor Standards Act, you have violated New York state law. I guess the moral of the story is make sure that under these circumstances that employees are relieved of all duties during their lunch periods. Another example is an employee who eats at their desk and answers the phones or otherwise performs duties and they're not relieved of all their duties. Again, they're going to have to be compensated for that time. Now, there are special rules having to do with what's called a one-person shift. But generally, that's the situation where that occurs is, let's say you have a factory and you have a night shift and you have only one person who's actually working in a department who knows how to operate the machinery and they're there. Well, then they can be allowed to, if they want, to eat their lunch at their machine. However, if that one employee on that single employee shift says, I want a duty-free lunch, then the employer has to shut the machines down or make other arrangements for that employee to get that duty-free lunch. But it really doesn't seem to have a good application to the school context. So basically, I guess my recommendation there is make sure that you are relieving all employees for at least 30 minutes. If they work a shift of at least 6 hours, that they are given at least 30 minutes lunch break where they're not expected to perform any duties. Attendance at in-service training sessions or meetings or lectures is also compensable, unless, and all four of these things must be satisfied in order for the person not to get compensated for it, for the non-exempt employee not to get compensated for it. That sounds like a double negative, doesn't it? If the person is entitled to overtime, they are going to be paid for attendance at in-service or other types of meetings if or unless the attendance is outside the regular working hours, the attendance is voluntary, the activity is not related to the employee's job, and the employee performs no productive work during the attendance. If you have an English teacher and the English teacher is going to a Zumba class, an exercise class after school. Well, that's attendance outside the employee's regular working hours. It's voluntary. It's an activity that's not related to the employee's job, and the employee is performing no productive work during that attendance. No productive work for you, at least. But I know that's a ridiculous example, but let's take that a step further, using that same ridiculous example. If you have somebody who is going to a Zumba class, let's say it's a physical education teacher. All right, well, is attendance outside the regular working hours? Yes. Is it voluntary? Well, unless you directed them to do it, it is voluntary. But is the activity not related to their job? Well, it may very well be. Are they performing productive work there? If they're learning a particular type of subject matter that they're going to be teaching in their class, then yes, that could be considered productive work. Would the employee have to tell you about it in order for this to become compensable time? Absolutely. But still, understand that your general in-service training, if it's done on the weekends, if it's done during the summer, it is not voluntary. That they have to be paid for that time. Time spent preparing for work. The biggest example that I can give you of this is bus drivers doing their safety checks before a route or securing the bus after their route. I know I've dealt with a number of school districts on the issue of bus drivers, and the issue usually comes up this way. Employee is paid under a collective bargaining agreement. It is estimated that the time that they are going to be spending doing their bus route in the morning is 3 hours and in the afternoon is 3 hours. So they're going to be paid for 6 hours. Well, the problem is, what if something happens during the bus run? What if the bus breaks down? What if they spend more time, if they're doing the safety check, they find something wrong with the bus? The problems can occur that will take them outside of that estimated amount of time that they're going to be spent working. And I got to tell you, folks, that is compensable time. They have to be paid for it. Well, but we have a contract, and the contract says this is what they get. I understand that, and I understand that the contract, in essence, sets a minimum that employee may get. But understand that the Department of Labor comes in and audits you and sees that this employee worked 5 hours and they only got paid for 3. I guarantee you that's a violation. I guarantee you that you will get fined for it. How are they going to know about it? Well, we'll talk about that in a minute. But believe me, they will certainly hear about it under typical situations where you're in a dispute over these matters. Travel time during the workday from one job site to another. I don't know if this is still the case. I've been an attorney since 1993 and representing school districts. In some capacity throughout that time. And I remember back years ago that BOCES would oftentimes have I think the term was itinerant teacher. I apologize if I'm getting the phrase wrong or the title wrong, but basically my understanding is that this particular teacher would spend part of his or her day at one school within the BOCES, and they would go to another school within the district, and they would travel around during the workday, and under those circumstances, the Fair Labor Standards Act says that is compensable time. The person has to be paid. Now, that's only for non-exempt employees, and I realize I just used the example of a teacher, and that wouldn't apply to a teacher, but if you had a non-exempt employee that works between buildings within the district. Let's say it's a cleaning crew or something of that nature, and they are traveling between the elementary school, the middle school, and the high school. That travel time is considered time work as long as it's during the workday. Travel time even overnight might need to be compensated, or if it's even on the weekend, if it cuts across their normal work hours. If your normal work hours are, let's say, 8 to 3, and you are traveling on a Saturday, I can't imagine too many situations where you'd have a non-exempt employee traveling, for an overnight purpose for the district. But let's say that that's the situation. Even if they were traveling on a Saturday, over that 8 to 3 period, they would be entitled to compensation for that time. Even if it's outside their regular working hours, the employee must be paid for any time spent where they're actually driving or performing other work. And that's always kind of the caveat is even if they're a passenger, if they are doing other work while they're sitting in the bus or on the plane or on the train, if they're doing productive work for you, clearly that is work that has to be compensated. This is kind of a special issue, but it came up within the past couple of weeks, and so I thought I'd bring it to your attention. Time spent seeking medical attention during working hours at the employer's direction is considered hours worked. We had a situation with one district where an employee had a seizure, and the employee, when they came out of the seizure, when it was a he, when he came out of the seizure, the school district was concerned, obviously, and said you need to go to the hospital, you need to go have that checked out and make sure that you're okay to come back to work. The employee did not want to go, but ultimately acquiesced and went. That's time spent working. Going to see the doctor at the employer's direction, that is considered hours worked, including the travel time to and from the place where the medical attention is provided, assuming that the travel time occurs during the normal working hours. Ultimately, if the employer then says to the employee when they come back, we want you to go for a follow-up visit, get a fitness for duty, so that you can return to work. Again, that's going to be considered hours worked and have to be compensated. Now, if that employee went into the doctor for the seizure and the doctor says, why don't I see you in 6 months, and the employee agrees to that, if that has nothing to do with what you've directed the employee to do, then that is not hours worked and does not have to be compensated. All right. So the first two issues have to do with whether or not the person is exempt from these overtime hours. Second issue has to do with what is considered compensable time. And as you can see, it can be kind of counterintuitive. There are situations where you really wouldn't think that the person would be entitled to compensation, and they are. So you need to be aware of that. You need to be careful that employees are not being paid simply on estimates. That can be a basis for how they're paid, but remember that they have to be compensated for all time worked, and that definition of that phrase "time worked" can be quite complex sometimes. Certainly, work with your school attorney anytime you have a question on those types of issues. Next thing I want to talk about is timekeeping. Remember how I asked the question at the beginning of the last section was, how are you going to prove the hours worked or not worked? Really, this is your way of doing it. Your timekeeping is your evidence. You have to think about it like that. You have to think about if I have a former employee that files a charge with the Department of Labor and says that they worked 80 hours for 6 years, and they didn't get paid overtime for it, how are you going to disprove that? Or how are you going to prove the converse? Or how are you going to say that this is exactly what the employee worked? The FLSA requires that you have an accurate timesheet or other method of timekeeping. Failure to do so creates a presumption in favor of the employee and is a violation. It's a technical violation of the Fair Labor Standards Act. But I want to focus on that presumption in favor of the employee. What that means is if you don't have an accurate record, Okay? Let's say you have a record, but it's not accurate, and the Department of Labor can prove that it's not accurate, the employee can prove that it's not accurate, then whatever the employee says they worked is what the Department of Labor will presume. So if you have a timekeeping system and it is inaccurate, for example, you have employees simply sign a timesheet which says, I worked 8 hours a day every day for 5 days each, or 7.5 every day. 7.5, 7.5, 7.5, 7.5. I'll tell you right now, that's going to be a red flag to the Department of Labor. I think I bring this up in some future slides, but I think it's important to bring it up now. If you are estimating what an employee works, let's go back to the bus drivers. They work 2.5 hours in the morning, 2.5 hours a night. They get paid for 5 hours a week, 5 hours a day, 5 hours, 5 hours, 5 hours, 25 hours a week, every week. Guarantee you the Department of Labor is going to come in and say, that's not accurate. They're going to go talk to the bus driver. They're going to say, did you work specifically that many hours to the minute? Oh, no, that's just what they told me to do. Now you have an inaccurate record, and whatever that employee tells the Department of Labor suddenly becomes the presumption. Okay? That's how serious this is. I also point out here, I know this is not a webinar about New York State law, but I also want to point out that the New York State Wage Theft Prevention Act also requires that you keep what are known as accurate and contemporaneous time records. And so understand that the accuracy of your timesheets and other timekeeping method is considered very important to the Department of Labor and can be very costly if it is not. Now, the law does not specify a particular timekeeping method. It can be a timesheet, it can be a time clock, it can be computerized check-in. You can even have a person designated as a timekeeper. The law doesn't care about that. Regulations specifically say we're not going to tell you how to keep time, but we are going to tell you that it has to be accurate. This was exact in and out time every day and total time every work week, exactly the same is going to be a red flag to the Department of Labor. If the timesheet is not filled out by the employee should review the timesheet and sign it and acknowledge that it's correct. And again, don't just tell employees to do it. Don't just tell them sign it. You have to sign it. They need to understand that they are checking to make sure that their time is accurate. It's pretty hard for them to argue that it's not accurate when they've reviewed it and signed it. That's your evidence. That's where you go to the Department of Labor and you say, you see, the week that they claimed that they worked 80 hours, here's the timesheet that they signed or initialed, and it specifically shows that they worked 37.5 hours that week. Boom, that case is over with. That particular week is done. Now, you might have to do that for, 52 weeks for 6 years, but understand that is your evidence, and that's how you go about avoiding those type of claims. Again, avoid timesheets that don't record actual hours worked, just present or absent. The timesheet should record actual time and hours worked, not just the contracted hours. Estimates of the number of hours worked or the average number of hours required to accomplish tasks may not be substituted for actual hours worked. And understand that it really cannot be a substitute for what they're paid. Now, again, if you have a contract that guarantees bus drivers, for example, I'm sorry to keep harping on bus drivers, but understand that it's an analogy, a much broader analogy. It could be for any employee for whom this is the case, a food service worker, an aide for that matter. But if you have someone who has a collective bargaining agreement that says they are going to be paid at a minimum for 3 hours of work, in the morning, 3 hours of work in the afternoon, then that can be a minimum. If they don't work that, they're still going to get 3 hours. But if they work 4 hours in the morning and 4 hours in the afternoon, well, they're going to have to be paid for 8 hours, and they're going to have to be given, you're going to have to calculate it based on, that contract estimate, that this is what you would normally get for an hour, and this is how much you're going to get paid for that 8-hour day. Let's talk a little bit about record keeping for both exempt and non-exempt employees. I'm going to run through this very quickly, but I just want you to understand that this is that the requirements are pretty similar, but the regulations, the FLSA regulations, 29 CFR section 516.2 says that you have to have the employee's full name, their social security number, and any other ID or payroll ID that you use for them. Their home address, including zip code, the employee's date of birth, the gender and occupation, the time of day and day of week in which the employee's work week begins, the regular hourly rate for which they're paid, and any overtime rate that they're paid, and hours worked by the employee each work day, and the total hours per work week, total daily and daily and weekly straight time earnings, excluding overtime pay, and then the total pay for overtime hours, and any additions or deductions from wages made for each pay period. Now, most of these records are not going to be in just one place. I mean, they're going to be in your payroll records, they're going to be on your timekeeping sheets, but understand that this is the information that has to be present, okay? The individual's, gender and occupation, does that have to be on their pay stub? No. I mean, it just has to be in the record somewhere. But understand, these are records that the Fair Labor Standards Act requires you to have. For exempt employees, it's pretty much the same, except you don't have to keep track of the number of hours they worked, or obviously they don't have overtime hours to keep track of as well. So you have to keep track of the total wages paid for each pay period, the date of the payment and the pay period covered by the payment, their name, social security or ID number, and ID number, not just one or the other, address and zip code, date of birth, all that stuff can be in their personnel file, gender and occupation, and when the work week begins. Now, generally, these records have to be preserved for 3 years under federal law. But again, because we're in New York State, you have to be aware that the New York State Wage Theft Prevention Act requires school districts and BOCES to create pretty similar records. I mean, you're going to see a lot of overlap here. And those records have to be maintained for at least 6 years. So you can't start purging those records even though you're outside of the purview of the Fair Labor Standards Act. Specifically, the New York Wage Theft Prevention Act requires the following records for each non-teaching employee for each week that he or she worked. Now, this is that issue that I mentioned early on. The misinformation out there about the Wage Theft Prevention Act does not apply to school districts or BOCES. Parts of the WTPA, or the Wage Theft Prevention Act, don't apply. For example, the WTPA requires private sector employers to give each employee what's called a notice of wage rate. And they have to give them that when they're first hired. They have to give it to them every year afterwards. They have to give it to them within 7 days of any change in in the rate of their pay. It's a real pain in the neck for private sector employers, and public sector employers don't have to do that. School districts, BOCES do not have to do that. However, the law modified the Minimum Wage Act section of the New York State labor law, which applies to certain school district and BOCES employees. The way that we interpret which employees it covers are certificated employees, or non-certificated employees, non-teaching employees, okay, the non-instructionals. That's who it's really going to apply to. And for those employees, this law requires, the WTPA requires that you have a record for each pay period that shows the hours they worked, the rate or rates of pay that they're paid, gross wages, deductions, allowances, if any, toward minimum wage, net wages, and there's kind of a catch-all in the law that says, and such other information as the commissioner may deem necessary. There hasn't been anything promulgated, or no regulations have been created thus far that where the commissioner has asked for anything more, but understand that could change in months or years to come. And if the individual is eligible for overtime, they're non-exempt, the records must include regular hourly rate of pay, overtime rate of pay, number of regular hours worked, number of overtime hours worked. Again, there's a lot of overlap between this and the Fair Labor Standards Act. Now, when I've talked about this Wage Theft Prevention Act in the past with other school officials, the question's always coming up, well, are you telling me that we have to keep track of the hours worked by our exempt staff? Unfortunately, there's no clear answer to that. Our take on it is that you should not have to keep track of the hours for exempt employees because they are just that, exempt from the overtime requirements. And why are you keeping track of hours unless you're checking for overtime? But really, we're without getting overly technical about it. This section of the labor law has a definition of which employees are covered, and it specifically excludes employees who are, the term is bona fide executive, exempt, and administrative employees. So typically it would exclude those employees. However, it has this one section at the bottom of that definition of employee for purposes of this Minimum Wage Act, which says the term employee includes the non-instructional or non-teaching employees for school districts and BOCES. So the question really becomes, what about is an assistant superintendent or a principal? Do you have to keep track of their hours worked? Again, it's not clear. Our take on it is no, because they would qualify for the bona fide exemptions, and so I would like to be a lot more clear about that. I'd like to be a lot more definitive about that, but I guess I want you to be aware that there is a potential that sometime in the future there may be a new regulation or a case where a court says, hey, you school districts, you have to keep track of the hours of the non-teaching exempt employees as well, including your transportation supervisor, your building and ground supervisor, et cetera. So just be aware of that. But again, I would not spend a whole lot of time doing that at this stage. I would only do it after there is some kind of ruling by a court or by the Department of Labor. All right, back to the Fair Labor Standards Act.
Mike, we actually have a question from a few minutes ago from Michelle Matisse. She wanted to know, in your experience, do most school districts use a time clock?
In my experience, it's no, they don't. There are some that are now going to it just because of the crackdown that the Department of Labor has been. I was going to talk about, and I will talk about it a little bit later, but I want you to at least be aware of it at this point. The Department of Labor, the Federal Department of Labor, over the last 2 years has increased its budget for enforcement and has hired, I believe, an additional 200 investigators, and they are doing audits on a much increased level. I've been doing this for 18 years, and I can tell you for the first, for about the first 15 years, I never, not in the private sector, not in the public sector, I had to deal with a Department of Labor audit, U.S. Department of Labor audit. State Department of Labor has always been a little more aggressive and a little bit more active in that arena. But over the last 5 years, the Department of Labor has audited at least 2 of our school district clients. And a number, just a large number of our private sector clients. And because of that crackdown, a lot of employers are now saying, because they're being cited, I understand that the audit is the scary, is the initial scary part and something you want to avoid, but the outcome of those audits and the amount of the amount of back wages that employers are having to pay as a result of that, primarily because of improper timekeeping methods or inaccurate timekeeping methods is I think, pushing a lot of employers toward a more accurate timekeeping method like a time clock. But I can tell you, my experience with the large number of school districts and BOCES that we represent, most do not have time clocks at this point. All right. I have kind of this next section is kind of a grab bag, but at least when I was putting this together, it seemed like they all kind of went together a little bit. But I want to talk about compensation methods and calculations under the Fair Labor Standards Act, and then kind of dovetail into a discussion of the volunteer service in the school district context. School districts, unlike or public employers in general, whether you're a municipality, a town, a village, a city, a county, a school district, BOCES, you are allowed one alternative to overtime pay that private sector employers are not allowed, and that is comp time or compensatory time. Schools may permit employees to accumulate and use compensatory time. That's 1.5 hours of comp time for each overtime hour worked. But understand this, you can't just do it, okay? You have to have some kind of prior agreement that allows you to do it. It has to be in your collective bargaining agreement, or if you have employees that are not represented, then there has to be some agreement between the employer and the employee prior to the work being performed. Otherwise, you're just going to have to pay time and a half in terms of money as opposed to time. One issue that comes up a lot in school districts is where you have employees that work, non-exempt employees, again, non-exempt employees who work multiple jobs at different rates. I had this situation not too long ago involving classroom aides and cafeteria workers who also served as bus aides. Bus aides got paid at a lower rate, and the question came up, well, how do we pay these people? Well, the hours from all jobs have to be combined in order to determine if the employee worked more than 40 hours in the work week. So it's not if you work 45 hours as an aide or a cafeteria worker, and then you'll get 5 hours of overtime, and in that same work you work 10 hours as a bus aide, and that just gets paid at straight time. No, that's not the way it works. Same individual works multiple jobs at different rates. You combine all of the hours to determine whether or not they have worked overtime. Then you have to blend, well, there's really one of two ways that they have to be compensated for that time. The most common way, and the way that it's done without a prior agreement. Again, the other way, you have to have a collective bargaining agreement, or again, if they're not represented, an agreement with the employees on how to pay it. But typically, the way it's done is you take the total earnings, including compensation from all the different rates. So if you have a cafeteria worker who's making $10 an hour, and they're going to also serve as a bus aide making $8 an hour, well, then you're going to combine the total earnings from both jobs for all, for all the hours that they worked that week, and then divide that by the total number of hours worked at all jobs. Now, that's going to yield the regular rate, okay? So I hesitate to give numbers on this, but I think it's the only way I can really fully describe it. So if you've got a piece of paper there handy, take down these numbers. Let's say that you have an employee who works 20 hours at $8 an hour, and then they work 30 hours making $10 an hour. Well, the $20, for 8 hours, that's going to be $160. $30 at 10 hours is going to be $300. So for the straight time that they worked for the week, that's 50 hours of work, so we know they worked overtime, but the straight time pay that they're going to be entitled to is $300 for the $10 an hour job and $160 for the 8-hour job, or a total of $460. Now, how do we determine what their overtime rate is? Well, we have to take that total compensation and divide it by 50. And we come up with we come up with the regular hourly rate, which turns out to be $9.20 an hour. Now, since the employee has already been, for purposes of our discussion, since they've already been paid $460, they've been paid straight time for all 50 hours that they've worked. So all they're entitled to now is a 0.5 additional amount of pay for each overtime hour. So it'd be half of the $9.20 for the 10 hours of work, or an additional $46. So that's how typically you would go about establishing what the regular rate is for a blended, or what's called a blended regular rate for multiple jobs, and then determining their overtime rate. And you can think of it that way. I mean, that's the way I like to think about it, but if you want to think about it in a different way, you could say, okay, the employee worked 50 hours, they earned $460. Let's divide that by 50. We end up with $9.20. We can pay them $9.20 for the first 40 hours that they worked. That's $368. And then for the 10 hours of overtime, I'm going to pay them time and a half. So that'd be $13.80 times 10, or $138. You end up at the same place under both ways of looking at it, or both approaches. You end up paying the employee for that week $506. And I hope that's not too confusing, but just let me if you didn't have an opportunity to kind of run through it, just bear in mind that you have to take the total earnings from all jobs that they work. You remember, you have to count all the jobs together, the hours that they work from all the jobs, and determining whether or not they've exceeded the 40-hour threshold. Then take all the earnings divided by the total number of hours that they worked, and that's going to be their regular rate. And you have to understand that for every overtime hour that they work, they have to receive at least time and a half for those overtime hours. Volunteer service, and I know that our time is starting to run short, so I'm going to kind of try to go through this as quickly as possible. Non-teaching employees, or the non-exempt employees who perform volunteer service for a school district, may not qualify as volunteers and have to get paid. The general rule is that compensable time includes work or services done at the employer's request, or at the employer's direction or control, or while the employee is required to be at work. Those are all going to be considered time worked. Well, wait a minute. The employee says they want to volunteer to do it. Well, that doesn't really matter. Let's use the example of the non-exempt employee who also serves as a volunteer coach. The question is really going to become, are they really a bona fide volunteer, or is this really an extra assignment? The way that the way that the courts are going to look at it is, could the employee choose not to show up and do the volunteer duties, or quit performing them at any time without any negative impact on their employment? So if you had a non-exempt employee who is serving as an assistant coach or a volunteer coach of the football team, and if they are free to leave at halftime and not come back, and that's not going to adversely affect their employment, well then, okay, yeah, you probably have a bona fide volunteer, and they wouldn't have to be paid for it. Otherwise, it's going to be considered an assignment, and the time that they spend doing it is going to be considered time worked for purposes of pay. I understand that a lot of school districts, they want to do the right thing. They want to be good to people, and they want to give a volunteer, some kind of a stipend. They want to give them some kind of money to really to show their appreciation for their volunteer service. But understand that can backfire. Typically, for it to be volunteer, it has to be unpaid, or if it's going to be paid, some nominal amount. A gift certificate to the local mall might be okay. But if you start talking about, okay, we're going to give you a stipend of $1,200 a year, well, okay, now you're probably in a situation where Department of Labor is going to say, well, wait a minute, that's compensated work. That's not volunteer work. So be aware of that. Really, I addressed this earlier, I think, but this next point on the slide in front of you, office staff who stay after scheduled work hours to perform school-related work, that's generally going to have to be compensated as time worked. If the employee is performing volunteer work similar to the job that they normally do and they're paid for, it's usually going to have to be paid. Give you an example. If you have a bus driver who says, I want to volunteer to drive the team to an away game, well, that's going to be considered time work. The only situation that I've come across where that is a valid volunteer situation is where the bus driver has a child that's on that team, for example. Under those circumstances, the courts have said, okay, the bus driver is really not acting as a bus driver, they're acting as a parent, they're volunteering, they're not getting paid for it. But understand that any time that a non-exempt employee is performing the same kind of services that they perform when they're working, it's generally not going to be considered volunteer work, and they're going to have to be paid for it. The last point there is consider a volunteer acknowledgement. In other words, have them sign something that says, I want to volunteer and I'm not going to get paid for this. And it's not a guarantee that the Department of Labor might not disagree with you, but at least it's some protection that there's some evidence that you can use to support your position on that. Some common pitfalls at school districts that we see school districts falling into when dealing with wage and hour issues. Bus drivers who are paid only for their scheduled hours or route time. As I told you about, I've beaten this dead horse quite a bit, I know, but that is a very common pitfall. If a driver breaks down or traffic causes delays in the completion of the route, the additional time spent must be counted as work time. Safety checks at the beginning of routes, securing the bus after the routes, that's all hours worked. If the drivers are even allowed to remain on premises, during their off-duty time and perform, various administrative tasks, whatever those might be, that's all going to be considered compensable time. Employees who are not relieved of all their duties during meal periods, if they're supervising students or if they're eating at their desk, answering phone calls and questions, they're not relieved of all their duties, they have to get paid for that time. Unfortunately, you may get cited by the New York State Department of Labor for failing to give them a duty-free lunch. Misclassification of exempt employees. Cafeteria managers, for example, are oftentimes misclassified. Why? Because they're actually doing the same work as the people that they are supposedly supervising. If they spend more than 50% of their time doing that frontline type work, they're not going to be properly classified. Non-exempt staff who attend in-service programs or staff meetings during the summer or on weekends for which they're not paid. Again, they have to get paid for it unless it meets that four-prong test that I mentioned earlier when I was using the example of the Zumba class. I hope you know what Zumba is. It's an exercise class, and I don't know really why my brain went to that, but there you have it. Employees who come to work early or stay late, again, remember, if you know that the employee is doing the work, even if you directed them not to, they have to be paid for it. They can be disciplined for not following your rules, but they have to be paid for time worked. School employees who volunteer for school programs and functions. Again, if their job, we just went through those rules. So if they're not properly volunteering, then they're going to have to be paid for it. Secretary calling substitutes from home or other employees or other employees who work at home, those at-home hours have to be recorded and compensated. The board secretary who stays late for the board meeting. Assuming that salaried employees are automatically exempt, it's not the way that it works. Again, salary is just one element of those exemptions that we discussed early on. So what are the ramifications of violating the FLSA? First of all, I wanted to talk to you again about this odds of being audited. Since the Department of Labor has increased its number of investigators and its budget, the DOL is actually doing quite a few audits of public school districts. I went through a report from 2008, 2010, and there were probably 250 audits of public school districts. I put more than 200 because, sometimes when you're reading those reports, it's hard to tell whether it's a public school, but well over 200 public schools. They are mainly larger districts, but understand that as they continue to add investigators and budgets, that it's not going to be just the larger districts that are in their sights. Audits usually, but not always, are the result of employee complaints. So be aware of that. They will do program audits, is what they call them, or just random audits. And again, they're going to typically go for the largest school districts because they're going to want to. I know this. I'm making them sound horrible. I mean, they're enforcing the law, but they're going for the big ticket items, the big violators, or the big violations, the large monetary back pay awards that they can justify their existence and report to the general public that they're doing a great job. And that's the reason why it's the large districts that typically get targeted in those program audits. We recently reported in our firm's newsletter, and I don't know if any of you got that, but I just wanted to touch on the fact that the U.S. Department of Labor has recently launched a new smartphone app that allows employees to keep track of their own hours on their smartphone, and it also includes phone numbers and contact information for the Department of Labor so that they can contact them if the results of their timekeeping records don't match up with yours. Obviously, this is likely to increase the number of complaints for employees. This is a free smartphone app. It works with most smartphones, and it scares me to death because of what I mentioned earlier, and that is that presumption of the employees' time records being accurate if your time sheets or time records are proven to be inaccurate. An employee, well, all they'll have to do is really pull out that smartphone and say, see, I worked 80 hours this week, and if you pull out a timesheet that says 7.5, 7.5, 7.5, 7.5, I'll guarantee you that you're going to be in for a huge fight, and the Department of Labor is going to side with the employee. So it's something to be aware of. So as that kind of thing increases, the likelihood of being audited increases as well. Understand that the audits will also have a broad scope. They're not just going to look at wage and hour issues. They're going to look and make sure that you have your I-9 or your immigration forms properly completed. They're probably going to look at whether or not you're complying with the Family and Medical Leave Act requirements. They're going to look for possible child labor violations, if any. Penalties for violations. District and even individual supervisors can be held civilly or even criminally liable for violations. They may be sued by the DOL or by employees where the employee doesn't bring suit on its own. Civil liability can include liquidated damages, which are in essence penalties. It's a set amount that they would charge for the violation itself. Back pay, injunction from any further violation. Injunction just means you're prevented from doing it any further. You are enjoined or prohibited from doing it any further. If violations are found to be willful, there are additional punitive damages that can be quite expensive. And again, there are those potential criminal penalties as well. Lastly, in the last 2 minutes we have here, I just wanted to let you know that the Fair Labor Standards Act does also regulate youth employment. There are a lot of state laws that do the same thing. When there is when both laws are applicable, understand, when I say both laws, I mean federal and state, the stricter standard is the one that always has to be obeyed. So, for example, there are prohibited occupations for certain age employees that for the federal, there's a federal list and there's a state list. The state list tends to be, at least in New York State, tends to be much more strict than the federal list, and so the state list is what you'd have to follow. But the Fair Labor Standards Act, for example, does not require minors to have working papers. But in New York, we all know that if the individual is under the age, if they are minors, they have to have working papers. Minimum age standards, basically anybody under 14 cannot be employed, at least not in a school district context. family farms maybe, but not in the school district context. 14 and 15-year-olds can be employed outside of school hours for a variety of non-manufacturing, non-hazardous jobs for limited periods of time, and I'll talk about that in just a second. 16 and 17-year-olds, they can be employed for unlimited hours in any occupation other than those that are on those prohibited lists as hazardous. And at 18, then the youth employment standards stop applying to you. For the 14 and 15-year-olds, I actually had a job when I was 15. I worked as a carpet cutter for a carpet retailer, and it was the worst job I ever had, I think. In reading this list, I found out that they were violating the child labor laws. Outside school hours, that what they followed. No more than 3 hours on a school day, they followed that because I worked from 6 at night to 9 at night. No more than 8 hours on a non-school day. I worked 8 hours on Saturday. That was fine. No more than 18 hours during the week when school's in session. They violated that one. I worked Monday through Saturday. I worked 3 hours a day. That's 15 hours for the week, and then 8 hours. That's well over 18. No more than 40 hours during the week when the school is not in session, and you have the work hours have to be between 7 a.m. and 7 p.m. Clearly, my former employer violated that because I worked until 9 p.m. every day. New York has, again, other requirements. A student of that age cannot work more than 6 days a week. They can also work in school cafeterias during work hours. During school hours, in the building in which they attend. And then there are some special rules that you should be aware of that at least that they exist for co-op situations if that comes up. The prohibited occupations are on the lists on the websites for the website that I've given you here is the New York State Department of Labor website, but it has both the federal and the state lists there. Violators, obviously, violators of child labor laws can expect to pay a lot of money, $11,000 for each violation, and God forbid that somebody gets hurt or dies under these circumstances. The penalties can be much more severe. But that's the program. I'd be willing to. I know we're out of time right now, but I'd be willing to stay and answer any questions that you may have on anything that's been discussed today.
Okay. If you have a question, please hit 7# on your phone. Okay, we have a question from Michelle. Michelle? Mike?
Yes.
Okay, we have Michelle on the line for you.
Okay, go ahead, Michelle.
Hi, Mike. I have a question regarding the volunteer.
Okay.
My district, we have a person who actually retired 2 years ago, and we hired her back to work, I believe it was 3 periods a day. With the budgetary situation, that's not going to continue next year, but she has indicated an interest in coming back in and volunteering, pretty much doing the same thing, but just not getting paid.
Right.
Do you see that as a problem?
What is the position?
She's a special education teacher.
Yeah, no, that would definitely be a problem because it'd be doing the kind of work that she has been paid for in the past. Probably not going to be allowed to treat that as a volunteer.
Okay. Okay, thank you.
You're welcome.
Okay, thank you, Michelle. If anyone else has a question for Mike, please hit 7# on your phone.
While we're waiting for any other questions, just a quick summary of what we've gone through here today. First of all, I think maybe it's my own sense of priority, but I think one of the first thing you need to remember about the Fair Labor Standards Act is who is exempt and who is not exempt. Follow those rules. Remember that it's the duties that really are the key thing to remember in establishing whether or not someone is exempt from the overtime requirements. The time worked, make sure that you are keeping good track of the hours that people work and that they are paid for all that time. And follow the record-keeping requirements. I know probably most of you do. Remember that it's going to be a 6-year requirement to maintain them under state law, not just the 3 years that the feds require. And remember that the penalties associated with violating with any of these violations can be huge, especially when you're talking about large groups of employees that can band together as a class and go back sometimes up to 6 years to get back pay. So be aware of it.
Okay, Mike, we have a question from Lissa. Lissa, go ahead.
Go ahead.
Lissa?
Actually, I'm sorry. I'm in for Lisa. My name is Tricia. I'm calling from Cara Durham. I have a question about timesheet records.
Okay, go ahead.
If an employee's normal hours are 8 to 4, but they show up voluntarily at 7:55, should they be writing that on their timesheet? And how do I have to pay them for every single minute to the minute, or how do I round it up, down?
All right, that's a great question, and the answer is, in an ideal world, you would pay them for every minute, but the Fair Labor Standards Act regulations have allow for what's called rounding. Okay, and what the regulation says is, you may have heard it referred to as the 7.5 minute rule, and I'll explain why it's called that in a second. But basically, what the regulation says is that we, the Department of Labor, we understand that, you might not be able to capture every minute that an employee works, but we think that if you round to the nearest interval of time that you keep track of, which can be as much as a quarter hour or 15 minutes, then we think that that's going to end up averaging out over a period of time that the employee will get all of the money that they are entitled to. What that turns into is a 7.5 minute rule. If you're going by a 15-minute interval, what the 7.5 minute rule says that if the person signs in or clocks in or whatever your timekeeping method is, if they clock in more than 7.5 minutes before the hour that they're supposed to start. Let's say they're going to start at 8 o'clock, and they clock in at 7:52. 7:52, you're going to have to round down because it's more than 7.5 minutes before the hour, so you're going to have to pay that employee from 7:45 instead of 8 o'clock. Conversely, if they sign in or clock in at 7:55, you can pay them from 8 o'clock. And the same goes if they clock in after the hour that they're supposed to start. But understand this: there are a rash of cases right now where unions have taken employers to court because they have made a study over a period of time that shows that the rounding practices of the school district have resulted in the employees not getting all of the money that they are owed. And when you spread that out over a period of time and over a lot of employees, it can be a significant number. So my recommendation is, if you're going to do the rounding, don't do it to a 15-minute interval, because that leaves just too much room, I think. I mean, if you could break it down to maybe a 5-minute interval and make it, in other words, a 2.5-minute rule, I think you'd be a lot better off. But again, going back to what I said initially, ideally, you should be paying for really every minute that is recorded.
So all the employees should write down the exact time. It's a flag right now. I think I have a flag. If every employee puts down that they work 8 to 4, some people should put 7:52 or 8:01 even. correct?
Correct.
Okay.
That is a red flag, and when the Department of Labor comes in and sees that, they're going to say, all right, I want to talk to 5 random employees, and I want to know, and the question to each of those employees is, what time do you start work? 8 o'clock. Well, what time do you really start? Oh, well, I usually get here 5 minutes before, 5 minutes after, and then suddenly your record is inaccurate, and then you've got trouble.
Okay. Even if the employee comes in to make coffee or something, but that's not work. So technically, if they come in and sign in at 7:55, make coffee, run to the restroom, since they're not starting work until 8 o'clock, is that?
What you just described is a situation that I would deal with, and I don't mean to use this word in a pejorative sense, really. I mean, but that's where discipline comes in. Okay.
Okay.
If an employee clocks in and then goes and makes coffee, has conversations, that's an employee that you need to talk to. You need to say, okay, look, if you're going to come in and make coffee and you're going to come in and have conversations, first of all, you might be disrupting somebody who is working, but second of all, if you're going to do that prior to clocking in. Clock in when your time to start is starting, because that's what we need for an accurate time record. Are you going to have to pay that employee for that 5 minutes because it's in the record? Yeah, you probably are, but you discipline the employee for creating an inaccurate time record. Do you see what I'm saying?
I do. Thank you very much for clarifying. Thank you very much for answering my question.
You're welcome.
There are no more.
Okay, we have no one else on hold. Any final questions for Mike, please hit 7 pound. Okay, Mike, we have a question from Deirdre. Deirdre, go ahead.
Yes. Hi. As a follow-up to the question that was just asked, how would it be if the timesheet had the notation office hours are from 8 to 4 unless otherwise noted?
You mean on a timesheet saying 8 to 4 unless otherwise noted?
That's correct.
Yeah, no, I think that you'd end up with the same problem. I mean, you would have to. Now, I say that, but I mean, I suppose if you have the employee check it for accuracy and sign it, and the acknowledgement that they sign is that I have checked and reviewed this, and this is an accurate reflection of the number of hours that I worked in this pay period. That's a pretty good record. But I hesitate to give it my blessing, so to speak, because it is exactly the kind of thing that the Department of Labor is going to. It's going to require further investigation. Okay, if you have, let me give you an example. Let's say that you have, let's say that they come in, the Department of Labor comes in and audits 2 different school districts. One school district has time records that show, 7:55, show 8:01, show 8:02, and clocking out at 3:30 and 3:25 and 4 o'clock and all that. They're not going to go and get employees under those circumstances unless, they have any other reason to doubt the record itself. They're not going to get random employees and say, is this how were these accurate records? Because they already look accurate, okay? Where you have a situation where it's the same every day for a period of time, that second school district that has that kind of a record is going to invite further investigation, which you may not want, because I'll guarantee you, any time that you have an employee that's answering questions from the Department of Labor, you never get the answer that you want.
Okay, fair enough. Thank you.
Okay.
Okay, final questions, please hit 7 pound. All right, that's it, Mike. Thank you very much for presenting on the Fair Labor Standards Act today. If anyone has any final questions that you don't feel like asking on the phone, please feel free to send me an email. It is mdarius@nysasbo.org, and I can pass along to Mike. Mike, thank you very much for being here today.
Thanks for having me. I really appreciate it.
And everyone have a great day.